Good evening, friends. Today we are going to start at the Indian Contract Act 1872. The Act has come into force from September 1872 and it is presently prevailing in all the states of India except state of Jammu and Kashmir. Now, this Indian Contract Act is the most useful act for the commercial and mercantile law because it states the importance of the contract and what are the various measures which can be taken if the contract are not fulfilled, and it states various types of contract as well. So how the act runs into the act is running into two parts. First part is general principle of law of contract, which are provided under section 1 to section 75, and there are special types of contract which are defined under section 125 to 238. This special type of contracts can be contract of agency, contract of bailment. So these are the various distinct type of contracts which are defined and their provisions are also defined. Now let us see which are the rights covered as per the contract. Friends, whenever the parties are entering into the contract, both the parties have got certain rights. Now first of all, let us learn about the types of rights. First is rights in rem. What do you mean by rights in rem? Suppose I am having a wonderful house like this, so it is only my right for or in that house. Nobody else can say that it is mine, it is their house. So this is the first part. So it is my right which I am enjoying against the whole world, and nobody can interfere into my rights. Secondly, it is rights in personam. Means what? Suppose I am entering into a contract with Miss A, then both of us have got reciprocal rights, and if these rights are infringed, or that the parties when they enter into the contract, they enter these rights, they enjoy this right, and these rights are only so far as the respective contract is entered. The moment the contract is over, the respective right is also over. But the right is, it is a sort of a privilege those persons are enjoying when they are entering into the contract. What do you mean by that? Suppose I am entering into a contract to get, say, a box through Amazon. I have bought a book through Amazon, and I have a right to get the book. At the same time, Amazon has got right to get respective price from me. So this is rights in personam. If I do not fulfill my part of contract, then I am infringing the contract. If Amazon is not delivering me the book within the prescribed time, then Amazon is infringing its rights. So it is rights in personam, which is generally covered under the respective and for the respective parties under the Act. Now, how the Act operates? How one can say that I have entered into a contract, and how the respective contract act parallelly applies to them. Now, suppose initially parties have the liberty to decide that how they will operate the respective contract, how they will carry out their part of agreement and obligations. So this is left totally as per their respective business terms, business skill, and their total will, provided all the things should be legal, nothing should be illegal. Secondly, what will happen, that the respective party have to perform their obligations. Once the contract is decided, Once the performance to be done by each party is decided, they have to perform their part of the obligation. And what will happen if parties do not perform their part of obligation? Then what will happen? Their non-performance will rise to some legal consequences. That is what the aim of and the object of the Indian Contract Act. So it gives a rise to some legal consequences when party do not perform their part of the contract. And as per the act, there are certain remedies and for the parties who are aggrieved, the parties whose obligations, who have not fulfilled the obligation, and so the opposite party, counterparty, can ask for remedies because either they have lost, they have faced some loss, or the contract has remained unperformed. So perhaps they may go to the court, or perhaps they may settle the account as far as the quantum of the work is done. That we will definitely see in detail in the coming part of the lecture. Now, considering what is the contract, how the contract is defined under the Act. Since so long I am speaking about the contract, how this Act is being performed. Under Section 2H of the Act, the contract is defined. The contract is defined as an agreement enforceable by law is contract. So what do you mean, first of all, an agreement? Friends, it's come on, take one by one term of the definition. When I say I'm agreeing, means what? That what the other party says, I am understanding the same thing in same sense at the same time. That sense, that particular arrangement is acceptable to me. So then this, the offer from one party and its acceptance from the other party makes an agreement. Now the very next step is enforceability. All agreements which has got force of the statute, force of the state, when a respective government says that look, this is the if any contract is entered into as per the definitions and as per the explanations by this act, then they are enforceable. Enforceable also means that it has got the force and it has got the pressure of the respective government. Let us take it another way around, that if suppose one agreement which is not acceptable, by the state, the government do not recognize those agreements, then can I go for those agreements saying that they are enforceable, my rights are not fulfilled? No, because initially only the government has said that the respective agreements do not get our force, do not get the recognition of the state. So basically an agreement which has got recognition by this law is a contract.